We will go ahead and call this meeting of the Senate Judiciary Committee to order. Mr. Clerk, if you could please call the roll.
Senator Berg. Present. Senator Carroll. Here. Senator Deneen. Senator Neal. Here. Senator Schickel. Right. Senator Stivers. Senator Storm.
Here.
Senator Turner. Here. Senator Wheeler.
Here.
Chairman Westerfield.
Chairman Westerfield had a conflict, so he asked me to go ahead and start the meeting. We will begin the agenda with Senate Bill 228, an act relating to driving under the influence of marijuana. Senator Turner, if you'd like to take the chair.
Thank you, Mr. Chairman. Senator Johnny Turner from the 29th District. Thank all you ladies and gentlemen for letting me be here today. This marijuana bill was brought to my attention by so you'll have some knowledge of why I've brought it. A county attorney brought to my attention that the county he lives in and was practiced in spent over $100,000 in the cases which he thought shouldn't be there by having to hire an expert when the defendant who had been charged with DUI went out and got an expert. And the law as it reads, if you got marijuana in your system, it's just automatically a charge of DUI. The Scientific Society has come to the conclusion that they can now test it by nanograms, and I think there's a consensus. There's a university physician, I won't mention the name, that's involved in this, and I provided information to the chairman, and this bill says if you have a 5 or more nanogram measured, and I've got some changes in here because it's got breath, but that's going to get changed, in your blood system, taken within cessation of 2 hours from the time that you're stopped or checked, that it's presumed that you're intoxicated. Alcohol presumption is 8%. Many years ago, it was 15%, but it got dropped to 8% over the years. And there's no testing now except just they take your blood test, and the whole world knows that you can be riding in a car and somebody's smoking marijuana and you're just inhaling it through theirs. It'll show up in your system, and that it can stay in there for 30 days. So this bill is trying to get something that's fair both to the public who may be around somebody smoking or somebody that smoked it a month ago or 3 weeks ago. And it'll save the whole government process, the court system, and everybody a lot of time and money and energy that doesn't need to be. So it's just setting a standard for a testing process, just like we do alcohol, to determine whether or not there's a presumption of intoxication and a presumption of being non-intoxicated, if you would say. So that's the length and duration of this bill.
We have a committee substitute, so before we proceed. All right. All those in favor, say aye.
Aye.
Okay, committee substitute is adopted. I believe Senator Carroll had a question. I'll turn it over to Chairman Westerfield.
Thank you, Mr. Chairman. Senator Turner, I'm in thinking about this, and I'm glad we're moving in this direction because I think it's going to make the life of our law enforcement officers a little easier. Many years ago when I was on the streets, and I could pretty much guess what someone's BA was going to be after they were arrested. We often talked about that to see how close we could get. With marijuana, and you may not be able to answer this, through the studies that establish this threshold, is there a correlation between the, let's just say the field sobriety test, that this level is consistent with the 0.08 as far as a suspect's behavior or coordination, or you understand what I'm saying? Is 0.08 very consistent with the level, the threshold in this bill with marijuana in the person's ability to function?
It's my understanding from Senator, with the gentleman county attorney who discussed this at length with me, and his involvement with a university professor a university doctor that comes and testifies him, and also he is hearing the testimony of different doctors that came to represent defendants who was charged with this, that this nanogram number is it's not magic, but the number that's in line with the 8% for alcohol. That's the standard, that you're presumed intoxicated, and below that you're presumed not.
But you don't know with the study that they did, was law enforcement involved in that? Where you could get some correlation between the alcohol and the marijuana levels to make sure that's a consistent level of intoxication. Really, I don't know that you can do that in a lab. I think it's more that, in doing research on individuals to really understand how it affects their coordination, their ability to drive, when you're looking at the blood alcohol and then the marijuana THC, whatever it is, it measures the content. But
Senator,
I'm sorry.
No,
Mr.
you're
Chairman,
fine. I wanted to offer something that might be responsive. I'm going to read an email that came from the state police. Just a couple of sentences here. KSB is unaware of any scientifically established THC level that correlates with impairment. To our knowledge, there are no objective studies that provide anything conclusive. KSB is aware of subjective studies where researchers attempted to correlate vehicle crash data with THC levels. Studies like these don't directly compare impairment with a level, but they can provide anecdotal information from which broad conclusions could be hypothesized. So that's where we're at. I know that, and I don't want to speak for the sponsor, I know that there are states that have the level set at 5. There are other states that have it set at 2. I don't know that there's any that vary between 2 or 5. And there are only about a dozen maybe states that have a level at all. That might be wrong. I'm not sure if that number, it wasn't a majority of the states, but it's something states are beginning to consider.
Okay. And I just wonder if any of those states have done that type of research with law enforcement. And
I have no
that
knowledge
doesn't
of that.
indicate from what. Okay. Thank you, Mr. Chairman.
If he can I further state that I had a lengthy discussion with the county attorney and their position, and I think he's spoken with a number of them. I told him to do that before he could get back with me. I didn't want to do this bill unless he'd spoke with a number of them that were involved in it. And it's just their experience that an officer that now, if a subject you stop says that I smoked marijuana a month ago or 2 weeks ago, he's going to get taken to jail and get a blood test to see that he's got marijuana system, and there's no quantification for that. You as the officer have the right to go in and testify to all the subjective information that you saw this person stumble, fall, walk, just like you do with alcohol. But he says the scientific basis is the only way that will help them. They spend over $100,000 for the same doctor to come and testify on this number. And there are studies that gives us, as the chairman said, difference, and there's some states that have this, but the consensus of him and the county attorneys who actually hear these doctors testifying all the time say that University of Kentucky physician who's real recognized say that the 5 is the magic number, just like 8 is. You remember years ago when you were an officer, 15 was the magic number for alcohol, and it dropped to 8. But now this magic number is what they say that all the physicians, they get other physicians that'll say that person is not intoxicated at 6 or 7. So that you still have differences like in alcohol from
and the different levels can manifest differently in different people in relation to their tolerance and how often they drink, how often they smoke marijuana. So that's where the field sobriety tests become a determining factor. I appreciate what you're trying to do, and this is definitely a road we need to head down. It's just making sure that is the proper number and having not just the scientific research, but the practical research with law enforcement who deal with these folks every day to making sure it's consistent.
And I look forward to working, with that, because they say their scientific studies can be made now. So, thank you, Mr. Chairman. That's all I have.
Thank you,
Senator Storm.
Mr. Chairman, I have 2 questions.
Fire away.
Senator, on page 3 of the sub, lines 14 through 17, it references a concentration just of 5. Would that be, just so the people that are viewing, that'd be 5 nanograms?
Yes, I'm going to do some amendments to get that. You see breath is in there that's coming out. So I stated I'll have to get that, and that's one of the corrections I'm going to make too. It's going to be the nanograms after that.
Thank you. And I just want also to talk to you about on page 4, beginning at line 27, up through page 5 on line 3. That is consistent with the alcohol presumptions regarding, so for alcohol, 0.04 to 0.08, someone is presumed to be, 0.04 on alcohol, they're presumed to be sober, correct? And what you're saying here is you're being consistent, saying if someone has 4 nanograms but less than 5, that individual is also presumed innocent. Is that accurate?
That's what the county attorneys says, that the general consensus between the professionals, doctors that are testifying, that's correct, and that's what they wanted in the bill.
I should rephrase that. Not under the influence as opposed to.
Yes,
Yeah,
that they're presumed not under the influence of the marijuana.
Thank you.
Any other questions? Seeing none. Oh, yes, Senator Berg.
You know, sir, I thank you for bringing this bill forward. I think this is actually needed. And my question, you may not be able to answer this for me, but this is a concern I've had for many years. Both of my children lived in states where marijuana was legal. And I was always worried when they flew home and got behind a car that maybe they could test positive. So you're saying that this bill basically would be an effort to see who is actually actively intoxicated versus who was using this product perhaps legally in a different venue.
Well, all lawyers that practice law with and DUIs where marijuana is involved knows that, and heard testimony that you can be riding in a car with somebody smoking marijuana or sitting with it. You're going to have it in your system, and if you just say that, yeah, I was riding with somebody that had marijuana, or if I smoked it a month ago or whatever, you will automatically be arrested, and you won't know that you're sober until the blood test comes back. Sometimes it's been 6 months before they get them back. So this is trying to at least quantify that takes care of your children and everybody else that's around somebody smoking marijuana, that they're not intoxicated by using the nanogram method that's been testified to by all these professionals, according to the County Attorneys Association, the people that's been in touch with me.
Thank you, sir.
Yes, ma'am.
We're going to have to have it anyway. Yeah. We're going to start somewhere. It's better per se.
Any other questions? All right. Do we have a motion on this bill?
Motion on the bill.
And we have adopted the sub. Yes. All right. We got a motion from Senator Wheeler and a second from Senator Berg. Seeing no further questions, Madam Secretary, please call the roll.
Senator Berg,
I vote aye, and thank you.
Senator Carroll,
Aye.
Senator Deneen,
Aye.
Senator Neal, Senator Schickel, Senator Stivers, Senator Storm,
Aye.
Senator Turner,
Aye.
Senator Wheeler, Chairman Westerfield.
Aye. Bill passes with favorable expression. We won't put it on the consent calendar because I know floor amendments are coming. So thank you, Senator. I appreciate it.
Thank you, Mr. Chairman, and ladies and gentlemen of the committee.
All right. Senator Southworth, come on down for Senate Bill 258, an act relating to discriminatory practices by state. And members, there is a committee sub here as well. Motion from Senator Schickel and a second by the chair. All those in favor of adopting the sub, please vote by saying aye.
Aye.
Those opposed? The sub is before us. Senator.
Thank you so much. I'm Adrienne Southworth, of course, from the 7th District, and we have here today the Act on Discriminatory Practices. So the goal and focus of this bill, which you'll see the first page is essentially all the definitions and the second page is the operative language, is to prevent discrimination against people who don't necessarily have access to computers, phones, whatnot, credit cards, those type of things. So we've seen a few situations that kind of highlight what this is about. In fact, this morning we just got word from the Transportation Cabinet, and they were one of the people that had been brought up as an issue over the last few years with these new driver's license systems, where they were not taking anything besides a credit card. And you get people that show up, they don't have a credit card, and now what do? And we've seen and we keep complaining about the multiple trips and the total inconvenience to our citizens. And I just think, to myself, well, what am I going to do when my grandmother needs her driver's license? Because we don't have a location in that area. So I appreciate that.
Got a motion from Senator Schickel and a second from Senator Deneen. I don't want to interrupt your presentation there. Anybody have any questions for the senator? Yes, Senator Schickel.
I have a comment if I'm allowed. Yes, sir. Thank you. I just want to thank the senator for bringing this. I see this in CDLs and bus drivers. We're screaming for bus drivers. We don't have any bus drivers yet. They've made the system so electronic that a lot of the older bus drivers don't have the means to process it. And so I think that's just one area where this legislation will help. And so thank you for bringing it.
Any other questions? So that everybody's aware, the committee substitute takes out, and now I can't remember what it was called before in the original bill, so I'm going back to it. It took out the reference to the term social credit score. So that social credit score definition, and then it was referenced later on near the end of page 2. That has been removed. That was the change in the committee substitute. Seeing no further questions, we have a motion on the bill and a second as amended by the committee substitute. Madam Secretary.
Senator Berg,
I vote aye, and I just want to tell you that last week I had to go and get my Real ID renewed, and they literally weren't able to take cash that day. I looked around and I thought, thank you.
Senator Carroll,
Aye.
Senator Deneen,
Aye.
Senator Neal, Senator Schickel, Senator Stivers, Senator Storm,
Aye.
Senator Turner, Senator Wheeler, Chairman Westerfield.
Aye, bill passes with favorable expression. We can put it on consent if you'd like.
That's fine.
Okay. Motion for consent made and seconded by Storm and Berg. All those in favor, please vote by saying aye. Aye. Those opposed, congratulations. Thank you.
Thank you.
All right. Representative Samara Heverin on House Bill 164, the inaugural House bill for the 2023 session before the Senate Judiciary Committee. House Bill 164, an act relating to jail standards. You have the floor, Representative.
Thank you so much, Chairman Westerfield. We appreciate the opportunity to present. I am Samara Heverin. I'm the 18th District State Representative. I represent all of Grayson County and part of Hardin County. I'll let my guests introduce themselves.
Hi, I'm Jason Woosley. I'm the Grayson County Jailer.
Jailer Josh Lindblom, Hardin County.
House Senate bill. Woo, giving myself a downgrade. Just kidding. Bad time to say that in a Senate committee, right? So what House Bill 164 does is it lowers the age for people to start working at jails to 18. Currently it's 21, and my jailer brought this to me, Jason Woosley, and then Big Josh, as he's known. Oh no, Senator Wheeler's making whispers up there. It's not good. So they brought this to me as a workforce issue. We have a really hard time going ahead and getting people to come to the jail. And I mean, think about it. You've got a 3-year difference. At the age of 21, most people have already started careers. And so this would just help them be able to hire people. Now, I've just worked out a floor amendment with Senator Turner that would require that 18-year-olds have a high school degree or equivalent. So a high school degree or a GED. And I'm happy to help work on that to get it to the floor. But I will let my guests say anything that they want to. One thing I do want to notice or want to mention is that if they're 18 years old, they're not allowed to be around inmates. This is more for administrative positions. So I'll give it over to my guests if they have anything to add.
So workforce is a big topic for everybody across the state, well, everywhere pretty much. But that's not just the only thing that we were looking for. Currently, I partner with the Elizabethtown Community College nursing program to let their students do rotations in our facility. But unfortunately, when they graduate, the ones that have come straight out of high school into that program are not going to be 21 when they graduate. So we would not have access to those students at all. And then second, we're really looking at finding better quality employees. And that might sound mean, and I don't mean it that way. My staff is top notch, and I would put them up against anybody in the state. But a lot of times what we find is we don't get access to the college students because they're not mostly looking to come to corrections when they graduate. And those that go into that field mostly go to law enforcement, not corrections. So we rarely get those college students when they come back from college. So what we're left with are the 24 and 25-year-olds that are having a difficulty holding down a job or might have a substance problem that we have to work with or try to help with. And that's not in every case, but that's a lot of what we have. So, you know, if they don't go to college once they graduate high school, they typically go into a career. The good workforce goes into a career, and then we don't get those guys back. We don't get access to them. So for my facility, we can plug these 18-year-old young adults in an office area to be mostly support or clerical work. But while they're there, between the age of 18 and 21, we can train them to be deputy jailers so that when they do turn 21, hopefully we've got them rooted into our facility and our system, and they'll stay with us, and they'll be fully trained at that time.
She beat you to it, Senator. We got a motion from Senator Berg and a second from Senator Schickel. You have a question, Senator?
Comment, if I may, Mr. Chairman.
Yes, sir.
Thank you. First of all, welcome jailers, and this is an excellent piece of legislation. As a former jailer, former president of the association, I have a special place in my heart for jailers, but I don't really think it goes far enough, and we'll work on that next session. There's no reason why an 18-year-old, can go to war for our country, but can't work in a jail. It's the individual person that you evaluate to see if they're going to work out. And the other thing is, if there's an emergency, it's all hands on deck, and you can't have certain employees not having prisoner contact. I don't think that's practical, but it's a step in the right direction. So thank you, Representative, for bringing it.
Any other questions? Madam Secretary, please call the roll.
Senator Berg. Senator Carroll.
Aye.
Senator Deneen. Senator Neal. Senator Schickel.
Aye.
Senator Stivers. Senator Storm.
Cast my aye vote and explain.
Yes, sir.
I'd like to thank the sponsor for bringing the bill, as well as the jailers that are here today. I practice federal criminal defense, and most of my clients would love to go to the Grayson County Detention Center. I spend a lot of time there. Used to go every Thursday, and it's not because the food's good, but it's actually a superbly operated facility. It's clean, it's well lit. They have areas for the attorneys. It's very safe, and appreciate all your good work over there.
Thank you, sir.
Senator Turner.
Explain my vote.
Yes, sir.
Thank you, Mr. Chairman. I also vote aye, and am pleased that this bill is as is, but I'll work with her to get these little amendments done and get this thing on through, because it's an excellent bill. My jailer's done told me so.
Senator Wheeler.
Mr. Chairman, explain my aye vote.
Yes, sir.
Also agree it's an excellent piece of legislation, and I would also agree with my colleagues, Senator Turner and Senator Schickel. I think a floor amendment may be in order to allow, the 18-year-olds to serve at all capacities. I mean, I don't see any reason why we should discriminate merely based on age. I mean, it really does come down to the person and training. So, it's a good piece of legislation, takes us in the right direction.
Chairman Westerfield.
I vote aye. Bill passes unanimously. Got a motion for consent from... It's okay. It's okay. They won't go on consent.
Senator Westerfield, would you mind to let my guest indulge himself?
Of course, please.
Just to talk about the 18-year-old being in any part of the jail.
Absolutely.
That's okay.
Senator Schickel and Senator Wheeler touched on it, but right now in the state of Kentucky, Department of Corrections can hire somebody working in the prison at 18, and the difference is it's sworn and unsworn. Like I said, we talked about it before about this day and age when you can work on a nuclear submarine, you can do that stuff. There shouldn't be any reason that somebody shouldn't be able to work on carrying a clipboard to the jail. So, but I appreciate y'all hearing this, and it's a big push in the right direction, especially with all the economic boom we've been having. It's gonna be even harder to get more and more people, and in the course of the time when we were able to train people and whether they go on to work as a sheriff's deputy or a police officer, they get a whole lot more compassion in their heart and everything else, and they see what happens in the end game and stuff. So I appreciate y'all hearing this. Appreciate everything y'all do.
I appreciate you both coming, making the trip. Representative, thank you for bringing the bill. There is one more question. I'm going to let Senator Carroll ask this question.
Yeah. Thank you, Mr. Chairman. So in DOC, it's you all are basically structuring this the way DOC operates. Those 18-year-olds cannot complete the full function of a prison guard.
Well, in DOC's standards, they're able to actually work as a prison guard. With the statute, the way it's set up now, it's sworn and unsworn. So deputy jailers are sworn deputy jailers. So they'd have different restrictions unless there's an amendment made. But yes. I mean, they'd be able to work inside the walls and do all that stuff too.
Okay. All right. Thank you, Mr. Chairman.
All right. Thank you.
Thank you. I greatly appreciate the Senate, and I know that Senate Floor Leader Thayer is watching currently, and so my apologies that I made any comment about the Senate being a lower body.
I appreciate y'all.
Thank you.
Thank you. All right. I do want to ask our guests, and listen, y'all, this is no one's fault but mine. I know we're done with the bills, but I want to give them an audience if they're still in the room. Mark Cowden and Destiny Pettit from their respective organizations, Normal and Community Forward. They both wanted to speak. I know one wanted to speak on the marijuana bill 228. The other might wanted to have spoken on that same bill. They didn't indicate which bill. But I want to make sure they've got a chance to speak. And I'm sorry I didn't call you up. It was sitting right here next to me, and I didn't see it and remember and call you up. But I wanted you to have the forum to speak and share your thoughts on this. Hey, push that little button to make sure that green light's on.
Thank you.
Yes, sir.
Destiny left when she realized we weren't being allowed to be heard earlier before the vote.
If you have a chance to share my apologies with her, I would appreciate it.
I will do so later. I wanted to bring 2 points that I think are important here on this bill in particular. And one thing is marijuana is not alcohol. And to bring that correlation is sophomoric. Now, if you look at the National Institute of Justice, I have it pulled up right here. They have a post from April 5th, 2021. Field sobriety tests and THC levels are unreliable indicators of marijuana intoxication. It's unreliable. And for a person to be faced with the potential of 5 years imprisonment over THC levels that may have been in the body days or weeks before being pulled over is wrong. And there's right and there's wrong, and right will win.
I won't speak for the sponsor, but I think an amendment is forthcoming to make sure it refers to active THC, so that we're not talking about the very scenario you just described.
Well, that's what the National Institute of Justice, that's their last word, field sobriety tests and THC levels are unreliable indicators of marijuana intoxication. Plain and simple. I hope you heard that. That's all.
Thank you. And again, my apologies for not bringing you up before. Senator Wheeler.
Thank you.
So exactly how would you propose that you test people that are smoking marijuana and driving down the road if you can't use either scientific testing or field?
I'm not an expert on that.
So you think they should just be able to drive down the road?
I don't think that this is the answer.
Okay.
I don't think this is the answer. I think there are potentially other answers. But I do believe that this test has been proven to be an unreliable indicator, and this bill, in my opinion, is unjust and should be stopped immediately.
Thank you, Mr. Cowden.
Thank you.
Is this Ms. Pettit?
I am.
Let me apologize myself. I'm sorry.
It's okay. I ran from the parking lot, so I'm a little out of breath.
It's no worries. I'm glad you were able to come back. That no one's fault but the chairs. The paper is sitting right here in my face. And I
It's
looked at
okay.
it
You all were
before.
asking about had testing been performed, and I'm like, I know the answer to that.
You have
So-
the floor, ma'am, if you want to speak.
Thank you. I'm obviously Destiny. I have AC for nonprofit called Community Forward, and we do progressive policy education, including the legalization of marijuana. The National Institute of Justice, which is part of the Department of Justice, has already studied this. April 5th, 2021, the report was issued finding that field sobriety tests and THC levels of intoxicated persons are wholly inaccurate. The Massachusetts highest court has also adopted that and said that police officers cannot testify unless they are actual experts in marijuana, the effects that it has on the human body. So that is actually problematic for our police officers and not at all helpful. This bill, it confuses me really because while we have lack of funding for public education, lack of funding for mental health awareness and addiction, our student counselors are 450 to 1 as opposed to the recommended 250 to 1 that our state report says. And we're trying to force bills through that are already proven inaccurate by the federal government. I think that our time would be better spent on prospering growth within the Commonwealth instead of picking apart things that have already been figured out elsewhere.
You might have asked the same question. I don't know if you heard Senator Wheeler's question to Mr. Cowden, but I guess in the absence of this bill, do you suggest an alternative? Because I think everyone can agree, regardless of
that
one's
it's
position
inaccurate.
Well, I think everyone can agree that we don't want people impaired driving.
Correct.
Now, where that level might be is arguably up for debate, but I guess I'm trying to learn.
But in passing a bill like this, you also open, like I have social anxiety. I do a lot of literature and research, but for me to speak to you all here, like I'm shaking like a leaf. I'm also a member of Freeway and an activist in Louisville. So for me to get pulled over by the police is a little bit different than for you to get pulled over by the police, you know, with my anxiety. That automatically is that cop's gonna be like, what's wrong with her? She's under the influence. I'm gonna take her to a blood test and see whether she's impaired or not. That opens up more problems for the judicial system that's already, you know, broken under the weight of marijuana legislation. I mean, our prisons are full of people that just had a little weed 2 or 3 times, you know? So, I mean, I'm not a scientist, I'm not a doctor, but I know that just kind of giving police officers the freedom to say, oh, you might be under the influence, I'm taking you, you know, off for a blood test and using inaccurate field sobriety tests to prove that you have the grounds to do that is not where you start figuring it out. You don't start figuring it out where it's already broken, where it's already proven wrong.
I appreciate it, Ms. Pettit, and I'm glad you were able to come back in here. And I'm sorry to make you
It's
run.
okay.
No one's
Thank
fault
you so
but mine.
much.
Members, that concludes our business before the committee. Anything else? We are adjourned.
So this was apparently take your less than a minute to go. Yeah.
Ben and I had so few things. But I'll see you around. Take care.
Megan, this is my friend. I'm Elena. Nice to meet you. Yeah, so you work